Hey all, good morning. Welcome to Beyond the Will. We're going to give our participants another minute or two to hop on. I see our count is growing. We're so grateful for your time, your willingness to be here as we are wrapping up the Making a Will Month, which is August of every year. So we hope this content is relevant as you are thinking about making your first will or revisiting an old one or thinking about additional estate planning tools. And as we are hitting 11:01 to honor everybody's time, I'm going to get us started. Thank you guys for being here. This Beyond the Will webinar is the first of what we hope will be many as we address the Make a Will month annually here at the Community Foundation. Thanks for joining us to this conversation about the benefits of wills and then other estate planning tools. My name is Christina Tony Schmidt, and I am the Senior Planned Giving Associate here at the Community Foundation of Greater Atlanta. Before we get started, and in an effort to respect everybody's time, I'd like to highlight a few quick housekeeping notes. First, this is a webinar format, so participants will not be on camera or mic. The chat feature is closed, but you are welcome to submit questions throughout the presentation using the Q&A feature, and those will be addressed at the end of our webinar during a designated Q&A time. This webinar is being recorded. So if you need to leave early or would like to share the presentation with a colleague or friend, a recording will be available via a link in a follow-up email later this week. And after the introduction, I will be turning my camera off, but I will remain with you through the presentation to help respond to any questions or additional comments as needed. And with that, it is my joy to introduce our opening speaker, Chris Miller. Christopher Miller is of the law offices of Miller and Chait and is an experienced attorney who practice focuses on trust and estates, taxation, and business law. With extensive experience guiding families through probate, estate administration, and estate tax matters, Chris brings a practical, common sense approach with his clients to create thoughtful estate planning tailored to their unique circumstances. Chris is particularly passionate about serving the special needs community and regularly speaks on special needs trust. He has also presented continuing legal education seminars on Georgia probate law and the Georgia LLC Act and authored a chapter on asset protection planning for physicians and healthcare professionals. He is a graduate of Emory University and Emory University School of Law and has been recognized as a Georgia Trend legal elite in taxes, estates, and trust. He is also deeply involved in the North Fulton community and currently serves as chair of the Board of Trustees of the Greater North Fulton Chamber of Commerce Foundation. Beyond his legal and community work, Chris is a proud alumnus of the Professional Advisor Leader Institute, or PALI, and is an active member of the professional advisor community where he works to elevate the importance of charitable giving. And I've had the opportunity to witness his commitment to philanthropy firsthand through his regular participation in ACAN's Balzer Giving Circle. Chris, thank you for being here with us this morning and for your willingness to share your expertise and experiences with our audience. We're grateful to have you with us. And with that, I'm going to turn it over to you.
Well, thank you, Christina. Those are very kind words and probably a little overselling of who I am. I am just a humble estate planner, and my passion is to work with people and to develop relationships with families and help guide them through the transfer of wealth from one generation to the next. So I've been asked today to share a little bit of a case study and explain how different types of charitable planning will work. I'd like to talk about a couple that I represented. First, I met the two of them in the late 20 teens and prepared for them a set of wills and a revocable trust. We did also the usual incapacity documents, healthcare directives, and powers of attorney, but I want to focus today on what happened as they passed away. So they were a childless couple, and they were struggling on how to leave behind the legacy that they had built over time for themselves. So they really had no family connections on the husband's side at all. There were some distant cousins, but the husband was an only child and his parents were deceased. And so he really didn't have any concerns or desire to have his family even notified when he passed away. And the wife had some extended family, a few nephews down in Florida, and the game plan was, hey, we want to make sure that they have an opportunity to select heirlooms when we both pass away. But the majority, and in fact, the entire estate of what we leave behind, we would like to leave to a charity. And so, in the classic Where the Red Fern Grows story, right? The wife passed away in late 2021, and the husband passed away in the middle of 2022 from heart failure. And so they left behind a house and they left behind investments and they left behind some retirement accounts. So what we did by putting the house into the revocable trust was allow the successor trustee to kind of walk in and without needing to go through the probate of the husband's estate, we wanted the successor trustee to be able to manage the house. Now, of course, the husband, after wife had passed away, had brought in a caregiver, a live-in caregiver. And after he passed away, the caregiver's response was, he promised the house to me. The answer from the successor trustee was, well, that's not really what the documents say. The documents provide for a chance for wife's family to collect personal effects. There were a few specific bequests to individuals, and then the residuary bequest was to charity. As successor trustee, I've got the obligation to work for the charity's benefit. I don't get to just hand out houses, right? And so it took a few months, but eventually the live-in caregiver found a new place to live and left the house, and the successor trustee cleaned out the house. One of the things that we found was the wife had been a potter. She was very active in the ceramics community and had taught at, I believe, the Sproul Center and perhaps at Callenwald. There were tons of packages of clay in the basement, along with two kilns. And so the successor trustee said to the wife's family members, hey, do you want any of this? And they're like, no, no, we don't do that. So we offered the kilns to charitable organizations as personal effects. The successor trustee invited the wife's nephews to come visit and put tags on things that they wanted, and then cleaned out the house. And it took a few months, but in the spring of the next year, the successor trustee was able to sell the house and distribute the sale proceeds to the charitable organization, right? So within about 6 or 8 weeks of the husband's passing, the successor trustee was able to gather the investments and claim the retirement accounts, liquidate those, right? And then start making transfers to the specific bequest beneficiaries. So there were, of course, some headaches, right? Um, the safety deposit box had not been transferred into the trust. So one takeaway that we learned in that case is make sure that the successor trustee, whether it's a kid or a friend or a professional, is also an authorized party on the safe deposit box because the banks weren't real fond of allowing access or removal of any of the property in the safe deposit box without letters testamentary. They would allow access to take an inventory with a probate court order, but no removal rights. And we didn't want to probate the will because that would require notification to husband. So eventually we abandoned the contents of the safe deposit box. The successor trustee had seen what was there, and it was a couple of watches, but nothing spectacular. All right. So another discussion point or another learning opportunity is the selection of fiduciaries, right? It's important when somebody comes in and doesn't have a clear family succession, and the goal is to provide for a philanthropic distribution, who then is in charge as successor trustee, who is named as executor. And so all of those things require thought and deliberation, right? I find that it's best to ask an individual to do some of the executor jobs. And there are a number of professional trust companies in the Atlanta community area that will gladly step in and then manage assets for a beneficiary over the long term, or just be the catalyst for distributing assets to the charitable beneficiary. So this case had a happy ending. There were a series of distributions to the charitable beneficiary. It took a little time. Having a trust to steer assets around probate doesn't necessarily mean it's all over, but it did allow us to accomplish the job without going through probate. So, another planning opportunity that we didn't have a chance to do with this case study, but I want to kind of plant in a seed in everybody's mind is the use of donor advised funds. That is a tactic that I am steering clients to with greater and greater frequency, often talking them out of complicated trust arrangements like charitable remainder trusts, and those are good tools, and they work. And some clients will come in saying, hey, I want to set up a private foundation with my assets when I pass away. And I try and talk them out of that ongoing overhead cost. If there is a way we can maximize the use of the charitable dollars without spending more money on lawyers and accountants and taxes, then let's keep it simple and do that. And so I'm a big fan of donor advised funds. I know the Community Foundation has a platform. There are financial institutions that have platforms, and it's a great way of making sure that charitable deductions are available in the year when you might have peak income, and you can then spread out the charitable impact and watch your dollars being used over time. So that's kind of my story. I'm now going to pass things off to Tim Bresnahan, who is the Vice President of Philanthropy at the Community Foundation of Greater Atlanta.
Thanks, Chris. Thank you for being here. Thanks for your ongoing engagement with the Community Foundation and for the excellent case study that you shared. I think you touched on a lot of the points that come up frequently in plan giving and in sort of post-death administration. We're going to touch on some of those today. So I love case studies. I think they're a way to make something more theoretical, very tangible and practical. And so thank you for your partnership and expertise. Hello, everybody. As Chris noted, my name is Tim. I lead the philanthropy team here today. I'm going to spend about 30 minutes on sort of a high level picture of sort of moving beyond the will. What are some of the tools and techniques that our donors are using to achieve legacy planning goals? And so I want to be really clear, this is not meant to be a college credit course. This is not meant to be continuing legal education. This is more of a high level overview. If you have more detailed questions, we'd be happy to follow up with you. But also, plan giving by its nature is very collaborative. And so we work with individuals like Chris, we work with CPAs, wealth advisors. And so this is an opportunity also to be thinking about who is your team of advisors that's going to help you achieve your giving goals. And so here's an agenda for today, but we can move right into the next slide. So what is a planned gift? And we've used a definition here from sort of one of the grand poobahs of planned giving, Robert Sharp. In essence, he describes a planned gift of really a gift of any kind, for any amount, for any purpose, whether given during life or deferred until after death, if it includes the assistance of a professional advisor, a professional staff person at a charitable organization, the donor's team of advisors, or includes any gift that is carefully considered in alignment with an estate or a financial plan. So that's a really big umbrella. A gift made during life, a gift deferred until after death, outright or through a giving vehicle. But I think at its core, what separates a planned gift from, say, writing a check is the assistance of a team of professionals, whether independent or at a charitable organization, and one that is aligned with other carefully thought out estate or financial plans. And so what's nice about this broad definition is it includes lots of different kinds of gifts and lots of different giving strategies. If we move to the next slide, they're small but mighty. So there's some data here from CCS, which is a fundraising consultancy, put out a broad survey of the state of planned gifts a few years ago. And you can see from their data, 0.1% of all donors sort of identify themselves as legacy donors, meaning they've included one or more charitable organizations in an estate plan or a planned gift. But nearly 17% of all fundraising revenue comes from legacy gifts. If you look at the most recent Giving USA report that reports on the sort of the annual report that's put out by the Giving Institute every year, in 2025, bequests made up 10% of all charitable gifts, which is more than $60 billion. So really, they're really important gifts. And as we are part of the great transfer of wealth that's happening, I expect we'll see more and bigger percentages of charitable gifts making up annual fundraising totals every year. They're also, they represent a tremendous multiplier effect of your average annual gift. And if you talk to individuals who have been in fundraising for some period of time, almost every fundraiser has the story of the $250 giver or the $1,000 giver who's given for 10 or 20 years, but leaves an estate gift of 7 figures. And planned gifts are often the outcome of your most dedicated annual fund giver. And so they're small, but they're very, very powerful tools. If we move to the next slide, why do people make planned gifts? And I think this is really important because, over the last several years, making a planned gift as a way to mitigate federal estate taxes that are due at death have become less of a driver. And I think a big part of that, to state the obvious, is the threshold for a taxable estate has gone up and up and up. And so currently, for an individual, just over 15 million, for a married couple filing jointly over 30 million. That means you need a pretty big estate to get to the threshold of getting hit with federal estate taxes. But that has not stopped individuals and families and couples from making charitable gifts at death. And so why do they do it? Well, one, I've heard throughout my career, both in wealth management and in philanthropy, that my children have enough. So even if you have a $12 million estate and you are not subject to federal estate taxes, you may have decided that, we've made allocations for our kids. They're both successful. They're both doing fine financially. We want the bulk of our estate to go to philanthropy. And of course, as Chris noted in his case study, rather, individuals who choose not to have children have to think about some disposition for their estate that's perhaps not going to the next generation. So this idea that estate taxes are the sole driver, not the case, especially for those couples that are thinking my kids have enough. Two, control. Even if you have the desire to include your children in decision making over some portion of your estate through charity, often through a donor advised fund, you may decide, you know what, I have a list of charities that are really important to me, or there are issue areas that I want my estate to support charitably after I'm gone, and I'd like to retain some control over that. And so a planned gift, a thoughtful planned giving strategy is a way for you to control after you're gone how those charitable dollars are used to support the organizations, the issue areas that you care about. And then three, something we're seeing more and more of an awareness that for donors that the community foundation can truly be a one-stop shop for all of your charitable planned giving needs. And so in theory, you could have just one charitable beneficiary of your estate, the community foundation. It pours into us, and out of that, we will make distributions outright to charitable organizations that you've named. We can put some into a donor advised fund for the next generation. And we can even create endowments that support named organizations or the causes that you care most deeply about. And so instead of having to tweak your will or your trust every time you want to make a change, you can do that with us. And it really makes the sort of the whole process really straightforward. We move to the next slide. Okay, so this is somewhat subjective, but I thought it would be helpful to put together a spectrum of not exhaustive, but the kinds of planned gifts that we often work with donors on. And again, you're going to get a copy of these slides after this presentation. So this is, a bit of a handy dandy chart for you to look at. But they range in complexity from something that should be rather straightforward, leveraging retirement assets, which are some of the best assets to use for charitable giving, all the way up to split interest gifts. When you're thinking about, as Chris noted, charitable remainder trusts, which may or may not be right for everybody, but for those individuals or couples where a CRT makes a lot of sense, they take a lot of planning, they take ongoing administration, and you have to be aware of the complexity that comes with doing your giving through something like a split interest trust. And so we're going to touch on many of these, so I'm not going to spend time doing a deep dive on this spectrum, but I thought it was visually helpful for you to understand that you can be at one end of the spectrum or the other, or have a planned giving strategy that includes multiple or even all of these different touch points along the spectrum. So let's move into actually sort of how people think about executing their charitable legacy plans. And even though this presentation is called Beyond the Will, it's important to start with the basics. And so for those of you on the webinar who do not yet have a will, I think I and Chris would implore you, it's the place where you should begin. Because while it's the foundation of your estate plan overall, to include philanthropy, hopefully, but your overall estate plan, everybody has an estate plan. It's a matter of, do you want to control what happens, or do you want the state to control what happens? And I think most people, especially those who have built wealth and have especially charitable planning aspirations, a will is a way for you to make sure that you are in charge of what happens. Now, there are some, every state's a little bit different. I moved here from Illinois. Illinois has its own regime for what constitutes a valid will. I think my number one piece of advice is work with a professional. While it's very easy to get online and to ask Claude to create a will for you, or to get, a template from an online system, the chances of it being only 95% correct is just, for me, it's too great of a risk. And so my strong number one recommendation is, if you don't have a will yet, or if it's been some time since you've looked at it, sit down with an estate planning attorney. We can recommend one. You've got one here on the webinar that you can talk to, and make sure that you have this done by a professional. Now, here is some sample language that you can use as a sort of kickstart. Through a will, you want to direct that you're bequeathing a certain dollar amount or percentage, or even specific assets. I bequeath my vacation house if it's an asset that's not in a trust, or a piece of art that you care about. You can use your will as a way to direct dollar amounts, percentage of your estate, or specific assets to achieve your charitable giving goals. Chris also noted that in the couple that he worked with while it was through a trust, they directed their residuary of the trust for charitable purposes. The same approach can be used for a will, of course. And so this is, I think, one of the foundational tools in your toolkit for charitable planning. If we move to the next slide, oh, we have a question here. And Enid, I'm going to take this question now because I think it pertains to this specific slide. It says, one concern that I've had is a stipulation in the agreement, something along the lines that the CFGA Board of Trustees have ultimate say over distributions. Have you ever run into an issue concerning this? Oh, thank you. This is from Angie. Hi, Angie. Hi, Enid. That's a really good question. So what Angie is referring to is in our boilerplate agreements, because the community foundation is the legal owner of the assets, we have to exert that control, meaning that ultimately our board of directors has ultimate authority over the operations of the organization and the distributions that we make. From a practical perspective, we are entering into agreements with donors. And so our number one objective is to satisfy donor intent. That means if we enter an agreement with you that, after you're gone, the Angie Fund shall only be used to support organizations that are focused on social justice issues or environmental issues, we can't use that fund for animal welfare. It would run afoul of donor intent, and we could actually subject ourselves to penalties from the Attorney General's office. What the language and the provision about the board having ultimate authority is, if for some reason that the provisions of a fund became impractical, the board would have the authority to ensure that we're doing something else that is as close to donor intent as is humanly possible. So one practical example of, we had a fund here created in the 70s that was used to support the research of and eradication of a very specific disease that stopped being present in the state of Georgia in the 90s. And so our board sought permission from the Attorney General's office to expand the scope of that fund to be used for general health purposes, because the purpose of the fund was impossible or impractical. And so it's a long-winded answer to your question, but it's something that we have boilerplate as a way to protect the legal ownership of the assets. But from a practical perspective, we're here to achieve donor intent. You're welcome. The next tool in your toolkit from a simplicity standpoint really is trusts. And Chris touched upon these, and so I'm not going to go deep into this. Trusts are essentially a legal relationship in which a trustee, whether it's an individual or a corporate fiduciary, holds property for the benefit of individuals or organizations, charitable organizations. The language of a trust can be very similar to the language of a will, except that instead of you directing a bequest through a will, here you're instructing your trustee to act in a specific way. Chris touched upon some of the benefits of trusts, primarily the privacy aspect, that if you do really leverage trusts as the primary holder of your assets, you can avoid probate, makes estate administration much easier. Wills can be subject to public disclosure. And so this is, especially for those that value privacy, a really great tool. And as Chris, of course, knows better than I do, they're often used in unison, where you have a will and a trust in combination. That's how my husband and I have our estate plan set up, is we both have revocable trust, we both have wills, and we both have revocable trusts. And they complement one each other in terms of the goals and the purposes of those documents. Okay, so we've talked about wills and trusts as the presentation talked about. Let's move beyond the will when we think about charitable planning. And I think something that is really foundational, really basic, but not everybody is still sort of fully embracing, is their use of retirement assets. Retirement assets arguably are the best assets to use for charitable giving during life, if you're of a certain age, or at death, because of the tax recent changes in the tax law over the last several years that have made, one, the ability to sort of pass retirement assets to the next generation over decades has become, much more condensed. And just maximizing from a charitable tax planning perspective, retirement assets are really effective. Now, there are a few ways you can do it. During life, you can direct retirement assets in the form of qualified charitable distributions. So if you are 70 and a half or older, you can make charitable gifts directly out of your IRA. Now, a qualified charitable distribution can start at 70 and a half. At 73, we start getting into the realm of required minimum distributions, RMDs. And so if you are at a certain age, you have to start taking distributions from your traditional IRA. You may not want to for for a variety of reasons. You may not want to have to realize that tax, that income, because it's taxable. And so you may say, you know what, instead of having to take my required minimum distribution, I actually want to move those dollars directly to charity. In 2026, I believe you can allocate up to $111,000 in qualified charitable distributions from a traditional IRA to charity, with the caveat as they cannot go to a DAF and a QCD cannot go to a private foundation. What you can do, however, is pre-fund your legacy giving using QCDs. So let's say in your overall charitable plan, you have a disposition in your estate to create $1 million endowment at your death that's going to be used for a scholarship program. Well, you could create that scholarship program at the community foundation, and you could use QCDs during life because a scholarship, an endowed scholarship, is permissible. You could put those required minimum distributions in the form of QCDs every year into that scholarship fund, and then use a portion of your estate to sort of top it off to get to $1 million. So it's a great way to think about using QCDs to fund what are much longer term legacy plans and legacy funds during life. Beneficiary designations are also a really important tool. So it's the primary mechanism for you to name a charitable beneficiary of your retirement assets after you're gone. Every custodian has a different form. So you reach out to your custodian, get a copy of the form, fill it out. You may need, for example, our legal name, our EIN, things like that. If you walk away with nothing today, please take this piece of advice. If you intend to use a portion of your retirement assets to fund your donor advised fund at the community foundation or anywhere else, but let's just assume it's at the community foundation, it's really important that you not name your DAF as the beneficiary. You have to name the Community Foundation for Greater Atlanta as the charitable beneficiary. The reason for that is the Tim Bresnahan Fund, a donor advised fund, is not in and of itself a legal entity. It is a component part of the DAF sponsoring charity, in this case, the Community Foundation. In previous lives, I have argued with custodians for 7+ years to get a retirement account moved over when the beneficiary that was listed was the DAF and not the sponsoring charity. So that's really critical. If you've named your DAF as a beneficiary of your retirement asset, this is a great opportunity to go back, double check your documents, double check your beneficiary designation, and just make sure you've named the Community Foundation and not your DAF alone as the beneficiary. Okay, if we move to the next slide. Life insurance policies. Now we're moving down the spectrum of complexity. These can be great vehicles, great mechanisms for charitable giving, either during life or at death. A couple of things to think about. One, what kind of retirement plan makes a difference? So often whole life policies are much better suited for charitable giving because they actually sort of accumulate value during life. And they can be transferred during life for cash value or transferred during life. And if the charity agrees, they can be held and owned by the charity so that upon your death, the distribution can go directly to the charity. Not every charity will agree to do that. So it's important to have a conversation with the ultimate charitable beneficiary to understand, are they willing to hold the policy? Many, including the Community Foundation, would much prefer to cash it out if it's transferred during life. If you're simply naming us as a beneficiary of your insurance policy at death and you're continuing to make the premium payments, that's sort of the best case scenario for us. We love that. Thank you in advance. Now, one thing to think about is, as I noted earlier in the presentation, because the threshold for triggering estate taxes has gone up and up and up. If you have a 20 or 25-year-old whole life policy that you purchased as a way to provide liquidity for estate taxes back when the exemption level was $6 million or $1 million, that policy may no longer suit the original intent that you purchased it for. So that might be a great way to look back. What do your insurance policies say? Do you still need them for the goals that you originally created them for, right? Because if you have a $20 million taxable estate and the threshold is 30 if you're married filing jointly, well, that insurance policy may actually be the best asset you have for charitable planning, charitable legacy planning after you're gone. So it's also another tip for those long held whole life insurance policies. Go back and double check with your broker, with your estate planning attorney, with your, whoever your trusted advisor is this still needed and what could we do with it? If we move to the next slide. So this is just, again, a summary where you might have a beneficiary designation and to go back and double check, is it filled out correctly? Does it name the charity correctly? We've talked about retirement assets. We've talked about life insurance. Some bank accounts allow a transfer on death. Some investment accounts may allow that. So this is just a friendly reminder, go back and check those beneficiary designations. Great. Now, Chris beautifully teed up this portion of the presentation, so thank you, Chris. For some families, a private foundation no longer makes sense for them to create one. They may have $8 million in charitable giving they want to do, they want to set it aside for giving. And at that threshold, with the ongoing administration, the excise taxes, the things that you have to do, $8 million may be much better suited in a donor advised fund. And so I'd say 15 years ago, when I was having conversations about charitable planning, the dollar amount was often the tail that wagged the dog in terms of do you do a DAF or a private foundation? Now it's really, what are you hoping to achieve? And if your goal is simplicity, you want to engage your wealth manager to manage the assets, you want to engage your family in giving, a DAF can achieve all of those with much less administration. But what happens if maybe you have a private foundation that was created by your parents, your grandparents, and you're sort of in a similar boat, that maybe this is a $9 million private foundation. It's being managed by 3 family branches, and it's actually more hassle than it's worth. This is a great opportunity to think, does the private foundation still work for me and my family? And if it doesn't, what are our options? Now, you have a couple of different paths you could take. One, actually working with a family right now. This is a private foundation that was created by the parents. There are 3 individuals involved in managing the private foundation, and they have decided to just take the foundation and to break it into 3 different donor advised funds. So they're working to dissolve the foundation. All of the assets will be distributed out to the community foundation. The foundation will close, and each family member will get to do their own thing. So that's one way. Another option is all of the assets in the foundation convert into a donor advised fund, and you use that one fund collectively for family giving. And we can talk about the pros and the cons. I've seen that work really well. I've seen it work not so well. But it is a way to keep the assets all together and to sort of require collaborative giving amongst the family. So that's another approach. A third approach is if you're sort of done, if you feel like you're done with the giving aspect, I once worked with a family where, the private foundation was created in Chicago, but nobody in the family lived there anymore. And it was a modest sized foundation, and they wanted to keep giving to Chicago, but there just was no connectivity back to the city. Well, they converted the private foundation into an endowment at the community foundation there. And the purpose of the fund was the exact same as the mission of the private foundation. And they sort of turned the reins over to the community foundation to do grant making. That's absolutely an option here that we can help you with. That if you have a very Atlanta-focused community private foundation and you're just no longer sort of interested in making the decisions around the grant making, but you still want to ensure that the dollars stay local, we can absolutely fill that role for you. So that's a really great way to think about converting a private foundation. Now, there's paperwork that comes involved. You have to ensure that you're checking all the boxes, and you would want to partner with an attorney to help you achieve a proper and sort of legally correct closing of the private foundation. but it's absolutely doable. If we move to the next slide. So I'm not going to spend a ton of time on this because this is much further down the path in terms of complexity, but I just want to flag it for all of you that there are still instances where a split interest gift, meaning a gift that gives some portion of assets to individuals and some portion of assets to charity, can still be a really powerful planning tool. I'd say out of these four, charitable remainder trusts are the most popular that we see individuals use. That is a split interest trust that makes distributions to one or more named individuals for a term of years or life. And at the termination of the trust, the balance goes to the community foundation, either to fund a donor advised fund or to fund a scholarship fund or some endowment. I've worked with donors over the years on charitable remainder trust where there really is a desire to both support an individual and there's very, very strong charitable inclination. I once worked with somebody who was herself an inheritor. She had inherited a substantial estate from her parents, and her daughter was an elementary school teacher. And she had very strong concerns about her daughter saving for retirement. And so she ended up creating a charitable remainder trust through her estate plan that would be created at death, that would provide a stream of income to her daughter for a period of years as a way to supplement her retirement. And at the end of the trust, the money would go into two endowments, one to support named organizations and one to support arts education. And so it was a way for her to both ensure that her daughter had a little bit of extra money because she had dedicated her life to public service and the teaching of children, but she also didn't want to give up the charitable part of her legacy plan. And so that was a great way, it was sort of a yes and approach. Now, this again is a handy dandy chart for you to take and look through. It's obviously not exhaustive because all of these are complicated vehicles, but it's a seed to plant to think about sort of what of these might be interesting to me, and we're happy to have a conversation with you about any of them. If we move to the next slide, finally, and I'm going to spend a little bit more time on this slide, I think really understanding the full suite and menu of options here at the Community Foundation is really important. And we can work with donors, we can work with all of you and your advisors to do one, some, or even all of these different funds within one charitable estate plan. And so, as Chris already noted, he, like others, are recommending more and more clients open donor advised funds. Many of you on the call, I can see very familiar names here. Hello. That many of you on the call have donor advised funds, and for that, thank you. A donor advisement, if you're not aware, is at its essence a charitable giving account that sits at a public charity. So in this case, a donor advisement of the Community Foundation is a charitable giving account that we own and manage, over which the donor has advisory privileges. So the advisor can recommend grants out to charities of their choosing. It can be funded, it's most commonly funded during life, but they can be funded at death as well. A variety of assets. If you're giving during life, appreciated marketable securities are the best asset to use. And we always push donors if you've got, if you were an early investor in NVIDIA or one of those other sort of, boom stocks, it's a great asset to use to fund a donor advised fund. It's a great mechanism for family giving. You can involve kids or grandkids, nieces and nephews while you're alive. You can create donor advised funds for them at death. They're just a really great flexible giving vehicle. However, they're not the end all be all of what we offer here at the Community Foundation. Our unrestricted endowment is really our engine for impact for the most pressing needs of the community. And so when we talk to donors that have some affinity for Atlanta, we always encourage them to think about some portion of their charitable estate plan be allocated to our unrestricted endowment. It's how we respond to the needs year after year of what's really happening in Atlanta. Right now we're using unrestricted endowment dollars to support affordable housing work. We're using it to supplement some of our arts endowments that we have. We're also using it to help nonprofit organizations as they adjust to changes in the federal funding landscape. And so it is, they're the dollars that are most nimble for us and the ones that really ensure Atlanta is in our primary focus area for pressing needs. We also offer designated funds. Those are funds that can be endowed or non-endowed that support specific organizations. I think about one of our designated funds here is a fund created by Philip Schutze, a well-known architect here, designed the Swan House and many other prominent buildings in Atlanta. In his estate plan, he left a bequest to the Community Foundation, a designated fund, where we make an annual grant to the Atlanta History Center every year to support the Swan House. It was clearly near and dear to him. He wanted to ensure that there was some stream of charitable dollars that would always forever be used to support that jewel. And it's something that we're every year for decades we've been making distributions to the History Center. And so if, when I talk about designated funds, I'd like to talk to donors. If you do annual giving year after year to a handful of organizations and you want those annual gifts to continue after you're gone, let's talk about a designated fund. Next is a field of interest fund. This is really focused on an issue area or a cause. Earlier I mentioned that fund, excuse me, that was created for a very specific disease and then was broadened to only support healthcare. That's an example of a field of interest fund. We have them for healthcare, for arts, for youth employment, for animal welfare. We can really craft a field of interest fund for any local cause that's important to you. And we can even tailor it towards a geography. If you really care about affordability on the West Side, we can create a field of interest fund for that. So it's a great way for you to take a cause that's really important to you and to always fund it after you're gone and to ensure that that issue area is always funded here in Atlanta. And then finally, many of you are aware of scholarship funds. Of course, they support educational opportunities for students. They can be endowed, non-endowed. They can focus on a variety of areas. We have some scholarships that are incredibly broad. We have some that are tailored to a specific school. We have one scholarship fund that's for vet techs. And so it really can be customized. And often those are very, very personal funds for individuals. They're often to recognize somebody in their family who was dedicated to education or, excelled in their field of study. And we'd love to talk to you about a scholarship fund. Again, this is a handy dandy chart. You can take it with you. And if you have a philanthropic advisor already here at the Community Foundation, you want to go deeper in any of these, that would be a great conversation to have. So as we think about wrapping up today, we move to the next slide. First, start with what motivates you. Now, there may be tax motivations, may be part of it. That's totally fine. But think about what really is driving you to think about your long-term legacy. Do you care really deeply about Atlanta? Do you care about a specific organization? Do you care about issues? Do you want your kids to be involved in giving? Start with those motivations, and then let's craft a plan together that builds off of what really motivates you and inspires you. Next, keep your estate plan current. Check in on that will, check it on the trust, check those beneficiary designations. If you are working with an excellent attorney like Chris, call Chris. If you've not talked to him in a while and say, Chris, it's been a minute. Let's revisit our estate plan and see, does it still make sense? Is it still meeting my goals? Next, double check those retirement assets. If you have not thought about leveraging them for charitable planning purposes, now is the time. If you have beneficiary designations, dust them off and make sure that they're accurate. Reevaluate existing giving structures. If you do have a private foundation that's been in the family for a long time and it's just not meeting your needs, we're happy to talk with you about that. If you have a DAF, if your DAF is the only charitable beneficiary of your estate plan, but you're thinking, wow, a scholarship fund or a field of interest fund might be really useful to me, we're happy to have that conversation with you as well. So revisiting all of the vehicles that you have currently in place to make sure that they're meeting your needs, happy to have those conversations and revisit that. And then finally, we really do want to be helpful in any way that we can. And we really do mean it when we say we want to be part of your team of advisors. So if you have an estate planning attorney, a wealth advisor, a CPA, family office staff, a best friend, and you want to include them in the conversation, we want to be sitting at the broadest table possible to meet your goals. And so if you've not thought about charitable estate planning, or if you've thought about it, but it's been a long time, and you want to revisit the conversation, reach out to me, reach out to your philanthropic advisor. We're happy to lend our advice and expertise and go deeper. And so we're at 11:50 now. We've reserved the last 10 minutes for Q&A. If there's anything I mentioned, if there's anything Chris talked about in his case study, um, and you want to go deeper, let's have those conversations. This is hello again, Angie. In this day and age, are you able to set up a scholarship fund and stipulate certain screens for selecting students? Yes, we are absolutely able to do that. In some instances, under the current regulatory regime, we have to get creative, but we are able to do that. And what I have also found is in some instances, we're able to be more bold and more creative than, say, a school would be, especially if it's a public institution. And so, yes, if you're thinking about a scholarship and want to talk through, um, you know, I'm happy to sit down with you and Amanda and have that conversation about what you're thinking, just to make sure that it's something that we can do and it aligns with your goals. You're welcome. What else is on people's minds? Anything I talked about that was confusing, or you want to go a little bit deeper on, or you've seen work and you want to share your success story? I'm happy to manage any of those. I also don't want to hold you back from lunch. So I'll put one last call in for any questions. Okay. Well, one, I want to say thank you. I want to say thank you to
Oh, I
Christina.
actually see a question. Can you clarify when or why you would have a will and a trust?
Oh, great. Actually, Chris, you're far
That's
more
why I
expert
stuck
than I
around.
am.
So a will is something that transfers assets that are owned by an individual in their own name when somebody passes away. And so if there was one little quibble that I had, Tim, your presentation was great. There was a slide that says trusts avoid probate. And I always cringe when I see that phrase
Mm,
because a will works together with a trust. A trust is like a giant picnic basket that holds things. And you can
mm,
put a house in there, and you can put bank accounts and investment accounts in there. You can designate the trust as beneficiary of your insurance and your retirement accounts. The trust is a great picnic basket, but it does not control what is in your own name. And so people die all the time with assets in their own name, like an insurance refund claim or
mm.
unused paid days off, right? There are lots of families that I have walked through the probate process just to get probate assets, even if they already have a trust. So a will and a trust work together. I will never work with a client just to do a trust if they don't have a good pour over will. And a pour over will, think of it like a lemonade pitcher. It just pours over into the trust. That's all that pour over will means is it just moves money from a decedent's pockets, right? Picture some dead person lying on the ground. You're rummaging through the pockets, right? The will is the way to get the money or property into the basket. And then the basket, the trust, will tell the trustee who the beneficiaries are, how and when to distribute.
Thank you, Chris. That's a great clarification. And I think in your point, it even speaks to the fact that in some instances, you're never able to 100% even get everything titled correctly because there may be things that pop up that are just you're not able to retitle them into the name of the trust, like unpaid vacation days. So they really do, you do have to think about all the things that could come to your estate in your own name, not in the name of the trust. I hadn't thought about vacation days. That's very interesting.
Yeah, they can add up.
Oh, sure. Yeah. Any other final questions? Great. Well, I want to thank Chris. First of all, thank you for taking your time today, for the great case study, for sticking around and helping to answer more technical questions, and just for your partnership. Thank you so much. Christina, thank you for kicking us off and organizing today. It's Make a Will Month. It's something great to be thinking about. Charitable planning, of course, is one aspect of an estate plan, but it's our favorite aspect. So happy to be having this conversation. Paige, thank you for organizing us today and all of your support. For those of you still on the call, thank you for joining us. Thank you for being interested. And if you are curious about your current charitable estate plan or you want to start the conversation, we are here to help. And we can get very creative, we can get very customized to ensure that your charitable giving needs are met both during life and after death. So everybody enjoy the rest of August as summer starts to come to an end and take advantage of Make a Will Month to do some planning. Thank you.